I'm just traffic. Just off the road.
Yes.
Yes.
Boy, he's out more than 7 years.
Working.
See, that's good transition school. Yeah.
Well, and they
Yeah.
know.
Okay.
Well, if they did, if they left me a message that it wasn't the proper number, well, wasn't the proper number. That's what Ralph said. Told you it was going to be quick.
I've been carrying.
Well, I appreciate you. Thank you.
How's baby?
Good. Growing like a weed. Yeah, it looks like his mom.
Make them have your hot.
Yeah, I hope I hope so. Thank you. Got work the road today. So I did.
Have you been?
Take one suit for another.
Huh? I said, you been somewhere? Okay.
Who is he?
I don't know.
It's nice to be here.
You missed it.
That's what I heard. That's what I heard. But we're all in sync. Purple.
It's purple there. You like big brother?
He's all about it.
Oh, Nancy.
Sure. All about it.
Yeah.
Oh, very cute.
So cute. Done with this today. My sister was texting me, was like, Ava's being sassy today. I want to well, you were on baby getter. Oh, I did. Yeah. Yeah. We had a great time. Yeah. Sometimes she's just in the mood. Like, it's like me. Yeah. My sister, like, she, exactly. Where she inherited her temperament. But no, my sister was like, no, I just, use your discretion. So she comes by and I was just like, it's one of those big things, look at it, and you're like, you're other stuff, it's like you're not even two. It's like, I get it. They got herself. I ain't even on her though. Here she goes. No, there she goes. Stop. Okay, what you want, something. Yeah. Yeah.
Okay, we'll go ahead and get started. Good afternoon, everyone. Thank you for being here. Today is the October informal hearing of the Tennessee Post Commission. The first thing I'm going to do is just go over the process for today and what it's going to look like. First thing, the agencies will have the opportunity to present first. Then the commission may ask questions of the agency. Following the agency's presentation, the individual respondent will have the opportunity to present. The commission may then ask questions of the respondent. After the individual has presented, the agency will then have the opportunity to provide a rebuttal, at which point the respondent then may provide us a rebuttal. Lastly, the commission will discuss and vote on the matter. Please note that this is an informal hearing. There will be no introduction of evidence, witness testimony, or cross-examination. The commission members reserve the right to ask questions, and if there will be a review of any items presented during the hearings. Now I'm going to read the chairman's conflict of interest statement. All post commissioners have previously agreed to recuse themselves from any vote that would constitute a conflict of interest. The most obvious of these would include issues that involve our own departments or someone we know. Because we have already agreed to this, it should be noted that on routine matters, it will be assumed non-verbally that these commissioners have abstained from the vote. In bigger, more controversial issues that may have a more overt conflict of interest, it may have appearance of impropriety. Those applicable commissioners will still verbally abstain from those votes. Now we will establish our primary voting members for today. We have Commissioner Jeffers, Commissioner Beverly, and Commissioner Wilbur. And I will start a roll call. When I call your name, please speak up so I can mark that you're present. Chris Gulliver. Chris Gulliver.
That's a surrender, ma'am, and it's agreed order.
Jerry Mifflin.
Here.
Michael Reagan.
Present.
Vincent Tyus. Vincent Tyus. Alfred.
Here.
How do you pronounce that last name, sir?
Margo.
Gerardo.
Yes.
Deontay Garland. Deontay Garland. Patrick O'Feely.
Present.
Did I pronounce that correct?
Yes.
Charissa Perez.
Present.
Todd Doris.
Here. May I approach?
Yes.
This matter is set for Kevin Creed, post investigator. This matter is set for today. Mr. Doris requested an attorney, and he's in the middle of getting an attorney through to PBA, and he's requested a continuance in this matter. It originally was set for September, but he was never notified, so this is the first setting. Okay, that's okay.
Legal has no objection to that.
There we go.
Okay, Darby Draker. Brandon Hodson. Brandon Hodson. Terry Millowan.
It'll be Milholland.
Milholland.
Yes, ma'am.
Okay, thank you. Joshua Potts. Joshua Potts. The first matter that we have today is going to be a voluntary surrender regarding Chris Gulliver. In this matter, we just need the commission to make a motion to set the signed agreed order into vote.
Commissioner Jeffers, I'll make that motion.
Commissioner Wilbur, second.
So we have a motion and a second. All in favor?
Aye.
Motion carries. The next matter we have is Jerry Midland with Fentress County Sheriff's Office. If there is someone from Fentress County, please step to the lectern and identify yourselves.
Post investigator Creed, this was brought forward to the post commission through an investigative report and investigative findings. So we are the ones who are seeking decertification on this from the formal hearing we had a few months ago, if you remember. So I'll start. On January 14th of this year, I went to Fentress County on a complaint through our portal, and legal assigned this case to a post investigator. to see if there was training done inaccurately and falsified into a CADIS through the Fentress County Sheriff's Department. The original complaint mentioned a school resource officer not completing firearms training, and also that the Sheriff Regan did not complete his online in-service training himself, and that someone else completed that in-service. So on the visit on January 14th, I did speak to GDI Milton and also Sheriff Regan. During those interviews, it was determined that Mr. Milton did conduct those in-service training hours for Sheriff Regan. I believe it was a total of 6 hours that was completed. I have, if you look in your iPads, there's, I believe it's crisis intervention for mental illness involving law enforcement response to mental crisis, police health and mental wellness, and Watch Your Six mental wellness resiliency. It was 4 classes, a total of 6 hours. By completing these hours for the sheriff, Mifflin falsified Regan's training record and also was making him eligible for salary supplement for the 2024 calendar year. We as Post intervened before the salary supplement was submitted to Post for disbursement of the $800. And we did not pay Sheriff Regan for the in-service hours since it was falsified training records. Mifflin did Mifflin did admit that he did complete these training hours for Sheriff Regan. He said it wasn't a, it was like an understanding. He was just trying to help him out. I have the actual quote. Sheriff Regan said, I did some of them. And I asked if that it's going to knock him out of a salary supplement. And Sheriff Regan said that would be all right. Sheriff Regan asked, will this decertify me? I said, he said, if they do, he'll just retire. And Mifflin stated in his quote, I just asked to get it done for him. I just helped him out. So the commission asked for this to come before you guys today for decertification on Mifflin for the falsifying the training records and possibly defrauding the state of Tennessee of the $800 salary supplement in 2024. That was intervened and did not take place, but it would have if we didn't go to that visit that day.
Commissioner, have any questions?
Commissioner Wilbur, just one question. Did Officer Mifflin say he volunteered or was told to do this?
I believe they didn't. I believe the conversation was there was no real agreement. He just asked to help him out. And Mifflin's, it's a supervisor, and he felt that it's the sheriff. He felt he had to do it, but he's here to answer the questions if you have it. That's pretty much the gist of what I got that day.
Thank you.
By speaking with him.
Mr. Mifflin, if you could step to the lectern, please identify yourself.
Jerry Mifflin.
Commissioner, have any questions for Mr. Mifflin?
Commissioner Beverly, I guess start off anything you wish to add.
Yeah, I done what I was asked to do. Sheriff said it was, I tried to keep everybody in line, keep everybody's stuff to get it done on time. We was rushed for time, pushing time, and he didn't go to the Sheriff's Association, so he didn't get those extra hours. He come to me and asked me if I cared to help get those hours done. Being my supervisor, I mean, put in a spot you don't know what to do, so I completed his hours. I had planned on resigning in January, but got a couple of cases I had to work, and I resigned in May after I got everything done and got everybody else's training submitted.
Is this the only instance this has happened?
It is.
Is this the only person?
Yes. I mean, I reset tests for people when they fail a test on B Academy. I've never took B Academy, but I reset tests. But I'd asked prior to doing that if you could, like when they fail it 3 times, if you was allowed to reset a test, and I'd get, I'd do that.
Commissioner Wilbur, are you currently in law enforcement?
No, I resigned May 31st and have not worked since then.
And do you have any plans to apply to work in law enforcement?
Well, I've been offered a position at a couple agencies, but I turned them down until this was over with. I know how long it takes to do paperwork, how much it costs, so.
This Commissioner Green, how long have you been in law enforcement?
I've been certified for a little over 11 years, been in law enforcement about 18, been reserve and part-time.
So you know that doing the wrong thing is doing the wrong thing.
Yes, sir.
So
Commissioner Beverly, again, I guess, I don't know how the rest of the committee would feel, but this kind of goes hand in hand. I don't know if we want to table this or then bring up the sheriff. That way we have all sides and we make a decision. Is that possible? Or do we need to move on this?
It's an informal committee, I'll make your rules.
What are your all's thoughts?
Commissioner Jefferson. Has this been turned over to the DA's office in that judicial district, or is this strictly just coming to us?
Kevin Green, post investigator. TBI is involved in this case, and I know they did interviews, and I do not know the actual ending result of their investigation. But the last contact I had with them, that this hearing would not interfere with anything they're doing.
If no opposition, I'll make a motion to table until we can hear from the sheriff.
So you would probably just need to roll him down the agenda.
We have not heard from the sheriff.
Yeah.
On any previous informal.
No, his lawyer is here today, but if you want to kind of change the position, the order of the docket, I think that's what the should be.
I'll make that motion to adjourn the docket.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Any opposed? Motion carries.
So, see.
Okay, the next item we have is Michael Reagan, Citrus County Sheriff's Office.
Kevin Green, post investigator. This is part two of the last situation. Pretty much the same facts involved. If you remember, Sheriff Reagan, his department submitted a waiver for him. And during the waiver, he was on a Zoom call. And I believe he told the commission that he was sorry for what he did and he please have mercy with him. I don't know the exact quote, but it's something of that information that he said to the whole commission. So pretty much acknowledged that this took place and just put his everything in your hands. But same circumstances. He was forthcoming during the interview with me when I went there in January. He did tell me that, you know, they didn't have an arrangement with Mifflin. He just asked Mifflin to help him out with his training, and that the 6 hours was performed by Mifflin with Sheriff Regan's request. But it wasn't like an agreement, like you do my hours. It was no return favor or anything like that to do it. And like I said earlier, the quote that was said by Reagan is, I told him this is probably going to knock you out of your salary supplement. And he said, that'd be all right. He asked me, will this decertify me? And I said, that's up to the commission pretty much. And they said, well, if they do, I'll just retire. So take that for what you want. But the 6 hours, once again, was fraudulently obtained. It actually falsified his state record in Acatus, his permanent file. And once again, the $800 salary supplement, if we did not intervene, would have been paid to the sheriff for this action that was created by both of these individuals. The last thing I'd like to say is Sheriff Reagan did say that he did not go to TSA for his training conference for the year 2024, and that's why the situation did take place. I did tell him during the interview that these training hours done by Mifflin were done on December 24th. All 6 hours was done on Christmas Eve. And I said, even you still had time to do these hours on your own. You know, you could have still done this before the end of the year, January, December 31st. And he goes, yeah, you're right. So the hours still could have been completed by him. So it wasn't a December 31st kind of event that they were scrambling, trying to get hours in. This was a week before the year ended. And V Academy, we know, can be accessed pretty much anywhere and complete those hours to get him in compliance with post.
Commissioner Wilbur, I just have a one question. Something about the sheriff wrote down the answers to the test. What is,
Sure. So on V Academy, it's not as bad as it sounds. The V Academy, like Mifflin said earlier, it gives you a few chances to take the test. And if you fail the test, it gives you pretty much what answers you've got right and wrong. So if you write your answers down and you take it again, you can figure out what the actual correct answers are. It's not a perfect system, but that's what those were originally. I did ask him about those sheets because he had them over by his desk. I originally thought that he was given those answers to go ahead and take the test himself, and that's why I mentioned it in my report. But by interviewing the sheriff, he did admit that he did trial and error on those tests and wrote the answers down as he went, stuff like that. So I don't think there was anything mischievous about those sheets on his desk.
thank you.
No problem. Any other questions?
Good afternoon, Attorney Jack Burris with Sheriff here. What I was going to say when I come up here changed when I heard Mr. Mifflin's statements. Sheriff has completed those hours that were done incorrectly, I believe in Acatus, and has about 50 hours for this year in there. But as you know, when we were here last time, TBI was waiting to do interviews and hopefully we're going to have their investigation done. Touched base with the agent yesterday, and the interviews, as far as the sheriff is concerned, were completed last month. TBI did not have an update for me as of about 1500 yesterday. And based upon that, at this point, and including some of the statements that were made today, what I would ask is that there be no action at this time on it and it be set for a formal hearing to be able to adequately defend the sheriff and present evidence to the commission. I'm going to have some of that stuff that TBI has. And based upon the interview that I was present for, I know I'm going to have that. And it would have an impact upon the commission's decision. So I would ask that at this point, no action be taken. It be set for a formal hearing. And I hate to ever do this, but they have told me they anticipate being done within the next couple of months, but they can't guarantee that. So TBI is, as everybody here knows, TBI is on their own track. So
Commissioner Jefferson, upon the request of Mr. Reagan's attorney, I make a motion to send it to the formal hearing.
1 second.
I'll second, but would you expand that? Commissioner Beverly, I'll second, would you expand that also for Mr. Mifflin in the same motion?
Absolutely. I'll go ahead and make a motion to include Mr. Mifflin there as well to continue out to a formal hearing.
Okay. We have a motion and a second. All in favor?
Aye.
Any opposed? Motion carries.
thank you.
Okay, next thing we have is Hamilton County Sheriff's Office, Alfred Gerardo. Is there someone here from Hamilton County Sheriff's Office?
Here.
Can you please step to the lectern and identify yourself?
Good afternoon, Commissioners. Lieutenant Mickey Roundtree with the Hamilton County Sheriff's Office Training and Professional Development Unit, and also the agency GDI.
Can you tell us a little bit about this matter?
Sure. This incident right here involved a pursuit that took place on January 28th, 2024. This began with Catoosa County Sheriff's Office in Georgia. They responded to a domestic disorder. This further escalated into a pursuit that turned into a known armed kidnapping suspect with a child in the vehicle. The pursuit continued into Hamilton County, Tennessee, with multiple agencies involved in the pursuit. Our deputies got involved on Interstate 24. They continued the pursuit on I-75. Deputy Gerardo spiked the tires on the vehicle on Interstate 75. The manner of deployment of the spikes was not consistent with our training as far as his vehicle was out in the middle of an open area with no protection to him. It was a successful spike of the vehicle. The vehicle did begin slowing down after depletion of the tires. At that point, after he had spiked the tires, Deputy Gerardo was the last vehicle in the pursuit. He accelerated up to the very front of the pursuit and began a box-in technique, which with our training and policy, it's not allowed for a box-in technique on a known armed suspect unless there's an extreme emergency or exigent circumstance. Once the box-in technique was initiated, the suspect did stop, did open fire on Deputy Gerardo's vehicle. Deputy Gerardo exited his vehicle, or started to exit his vehicle, began firing towards the suspect. Suspect, one of the rounds did strike Deputy Gerardo with, I believe, a shrapnel. Deputy Gerardo then kind of went back into his patrol car, began firing his rifle. It appeared from the video that he did not have a sight picture when he was firing back towards the suspect. The backstop of the shooting area was multiple law enforcement personnel and patrol vehicles, with approximately 15 to 20 patrol cars involved in the pursuit. Two of our deputies were struck. One was struck by gunfire from Deputy Gerardo. The other one was struck by shrapnel. They didn't know that until after the fact when he got home and took his uniform off. Internal Affairs conducted a review on this, and after a due process hearing, Sheriff Garrett terminated Deputy Gerardo from a law enforcement capacity and offered him a civilian position.
Commissioner, you have any questions?
Commissioner Wilbur, what policies were violated during this incident?
So he was sustained on the policy of violation of neglect of duty under our code of conduct. Also sustained under unsatisfactory performance under our code of conduct. He was sustained under a law enforcement role and authority of use of rifle policy. I failed to mention on that part that at the time our policy forbid the use of suppressors on weapons. He did have an unauthorized suppressor on his weapon. So he was sustained on that. He was sustained on response to resistance policy for a risk to innocent bystanders. He was sustained as policy violation on roadblocks, forcible stopping, boxed in, and spike strip deployment. Yes, I'm sorry, sustained on that under two different sections, the Stinger spike system and the box-in technique.
Thank you.
Commissioner Beverly, was a child in the vehicle injured at all?
Yes, and the last information they had during the pursuit before the box-in took place was that the child potentially was in the suspect's lap. Luckily, when this took place, the child had moved over somewhere else in the vehicle, was not struck by gunfire.
Outside of that, were they armed?
Now,
Commissioner Jeffers. The gunfire there, just so I'm clear on that, did the gunfire come from the officer that wound up hitting the individuals in the vehicle?
so the suspect was struck some, I believe by Deputy Gerardo's fire, but also there was a couple of other officers on scene that approached at different angles. They engaged the suspect with handguns.
What was the answer given for having the suppressor on the rifle?
I wasn't part of that interview with IA, so I'm not sure. I don't have that information in their report, so I'm not sure what their rationale was for that.
Thank you.
Commissioner Green, can you tell me how many rounds were fired by the deputy? You know,
So the report that I have, Deputy Gerardo in his interview with Internal Affairs stated that he fired his rifle until the magazine locked back, which we typically are, the way we teach to load our magazines is with 25 rounds. And it appeared most of those were fired without a sight picture. As far as the other, suspect fired several shots. I don't have that exact, I'm sorry, 4 shots of the expended casings the suspect fired. One of the deputies fired 1 shot from his handgun. 2 other deputies, I don't know how many rounds they fired.
thank you.
Any other questions? Thank you, sir. Mr. Gerardo, could you please step up and identify yourself as elected?
Alfred Gerardo. I absolutely did spike that vehicle. I was exonerated by Sheriff Garrett for that, saying that he did not have a problem with me spiking the vehicle. In that case, that charge was dismissed, along with the suppressor being on my rifle. That charge was also dismissed. The reason I had a suppressor on my rifle is because I was told by a firearm instructor that we were allowed to have it. However, the new policy had not come out yet, so I was not technically in policy with that. But Sheriff Garrett said that because I was told by a firearms instructor that we were allowed to have it, that because I didn't have will or ill intent. And as soon as that new policy came out, I submitted everything. Every single thing that Lieutenant Roundtree said is 100% true. I spiked the vehicle. I got up from the back to the front. The reason I went up there is because there were multiple agencies out of their jurisdiction, and in the Hamilton County Sheriff's Office, we pretty much say that Chattanooga won't do anything. It's not because they don't know how, it's because their agency wouldn't allow them at the time under their leadership. I wanted to get up there to help my guys. I'm a father of 5. Right? If my child was in danger, I would want to make sure that my child was taken care of. A lieutenant and a sergeant said over the radio, if someone can get up there to find out where that kid is, right? Because they weren't going to allow a pit at that point. I then proceeded up there to place myself in the danger once I was getting up towards the front where I could look into the vehicle. The lead deputy in our pursuit said, car 736, get in front of him. By our policy, right, you're only allowed to pass the pursuit if given permission by a supervisor or by the lead deputy in the pursuit. I believe that I had that permission at that time. Once I got in front of him, I did everything I could to prevent him from getting past me, which ended up in us doing a boxing technique. As soon as we got the vehicle stopped, I came out. I started putting direct fire on the individual. Right? I put 18 of 25 rounds into about a 1 foot diameter section in that windshield. Right? In that time frame, then when I was struck, I'm a combat veteran. I've done multiple tours to Iraq and Afghanistan. I've been in some of the worst battle places that you could be in, from Fallujah 2004 to the Argonne River Valley in 2010. My military training kicked in when I got hit, and I went directly from direct fire to suppressive fire and just tried to lay a base fire down. That was just a natural instinct for me in 21 years of training, education, and experience. I was wrong. I'm suffering from PTSD from the day, not from killing that guy, but because I wounded a fellow deputy. The second I saw his arm, I knew that that round was from me. And I told my captain, I told everyone, I told the chief at the time, right, that I have to find a way of living with that. It affects me to this day. It affected me after that to where I went from having amazing evaluations, right, being recommended to go to SWAT, being recommended to be an FTO, right, being recommended to be a UAS operator, right, all these different things, you know, that I wanted to do. My PTSD from that point on just screwed me up to the point that I couldn't do a job that I loved doing for 23 years. Couldn't do it anymore. And I went to my sergeant and said, I'm having problems. I'm not safe. Right. I was then sent out to do a mental health evaluation. I was off duty for 6 weeks, right, to where the sheriff's office, you know, psychiatrist and my VA psychiatrist were working together. My meds got adjusted, everything like that. When I came back after 6 weeks, it was like night and day. I'm still to this day doing therapy, trying to, you know, deal with all this, right? I was never terminated. That's one thing I don't understand by this. I was reclassified. Nothing in the documentation that I've ever received from the sheriff's office says termination. It says reclassified. I was reclassified from a patrol deputy to a property and evidence custodian. And that I love doing law enforcement. I would love to one day go back to doing law enforcement. I can't right now, not until I get my head clear. Thank you.
Commissioner, do you have any questions?
Commissioner Jeffers, question for the lieutenant.
Yes, sir.
What is his current status as far as employment? Is he completely terminated from the Hamilton County Sheriff's Department, or is he still in his?
He's employed as a civilian employee with our property and evidence division.
Commissioner Beverly, it's an odd question, but some agencies do it different. Do you guys issue badges to civilian employees, or do they wear any insignia showing that they are an employee of the sheriff's office?
Typically with the civilian employees, their ID cards look different than ours. And instead of a badge or an insignia, it's written out Hamilton County Sheriff's Office and only whatever unit they serve in.
Okay, thank you.
Commissioner Wilbur, I have a question for Mr. Gerardo. Do you dispute that the TBI discovered that there were 19 bullet holes on the driver's side and that you had shot most of those?
No, I absolutely,
Did you know where the child was when you were firing these shots?
at that point when I was receiving fire, ma'am, I was just returning fire.
But you knew there was a child in the car?
Yes, ma'am.
I'm wondering if my fellow commissioners, would we want to do a surrender? Or a temporary surrender, or what's the temperature?
That was a four-way range, ma'am. There was rounds coming from the front, the back, and both sides. Every single deputy that day was firing towards the direction of that child, and I'm the only one standing here today.
But you said you were not in a good mental space. Are you?
Afterwards,
Are you in a good mental space now?
but yes, now that my medication, all my mental health stuff started after that shooting, after I know that I struck another deputy. That's what messed with me. That child walked away. We were called a hero by the sheriff and by everyone else. You know, it was said in the press that that baby is with their parents today or with their mom today because of our actions. And if we hadn't have done that, there's no way to know if that child would still be alive.
My final question for you, sir, is do you think you did anything wrong?
Yes, ma'am. I absolutely do.
What was it?
I did not maintain my proper sight picture. When I got hit and I went into my military training, the stuff that I did in foreign countries under fire, you can't do. You know, we're responsible for every single round that comes out of our weapons.
Thank you.
You know,
I have a question for Lieutenant. Commissioner Green.
Yes, sir.
He's in civilian status now.
Yes, sir.
Would he go back through a psychological fitness for duty before you reinstated him? Or is this a permanent position?
My understanding is this is a permanent position, and the sheriff asked for his decertification.
Now I'm back to Beverly. What are your long-term plans?
my long-term plans is I love being in law enforcement. I love helping people. I am the guy that's willing to run towards the sound of gunfire instead of running away from it. I want to get back out there to help people. Can I do that right now? No, I still have, a road ahead of me, but I want to one day get back to where I can.
So if your status does not change with Hamilton County Sheriff's Office, would you leave and try to seek employment in law enforcement capacity with another agency?
Not until I know that I'm in a good mental health state.
But you would, once you feel like you're in that position?
Yes.
Commissioner Beverly, I think I want to echo what my fellow commissioners just asked. Most of the folks in this room have been in those situations that you have to make a decision instantly and you don't get the luxury to discuss it after the fact. And I can understand a great degree of what decision you made and what led to the decisions you made on that in that incident. However, I think the concern we have is what you're describing your mental state right now. And what the decision made today is whether or not you can then go apply with an agency elsewhere. That's kind of echoes.
That is my personal opinion of myself. I hold myself more accountable than everyone else. I've already passed the fit for duty eval to go back on patrol from the sheriff's office and from the VA.
And I think that's what their concern is. You pass the fit for duty, but yet by your own admission, you're not there yet. And that's the concerning portion. And so
better that I'm sitting there and holding myself to a higher standard than them.
And that's my question. How much time do you have a timetable you think you would need?
I have about 3 more months of my current therapy that I go through to where I go twice a week until it's either right before Christmas or right after Christmas. I'd have to look at my calendar. And then everything is set up in a 16-week cycle.
the intention of these questions are, I'm leaning towards not decertifying you, but giving you enough time to where you would be able to get back to where you need to be. And we can revisit this. You understand?
Absolutely.
So that's why I asked for a timetable, and I think that's where you were thinking as well. So would you be open to surrendering your post certificate for 3 months and then coming back and
Would it be a surrender, like just a suspension of this?
suspension?
It would be a system.
Suspension, my apologies, a suspension of your post certificate for 3 months, and then we can revisit this.
Absolutely.
That,
Let's, just to be on the safe side of that case, things get kind of prolonged or so on. I would go with the 6 month, then we could wind up coming back with that. That way, just in case, holiday season's upon us and things have a way of getting postponed.
Absolutely.
Things, so. Legal.
So if the commission was open to a 6 month suspension and if he was agreeable to it, so the term of the suspension would require, just so everybody's on the same page, would require him to be listed in the NDI as suspended for that period. And then he'd have to find a hiring agency to put him on the agenda to be reinstated at that 6 month time. So there would just be that additional barrier to reentry where at 6 months you have to do a new site, new meds, new pre-employment, and then bring your hiring agency with you to be reinstated. So as long as everybody.
So I would, in that 6 month time period, I'd have to go get hired by a new agency?
You wouldn't have to, but you would not be reactive, like your post commission cannot be active if you're not employed as a law enforcement officer.
Yes.
So when you, say you took 2 months or 2 years and 9 months off, ever going back, that's fine. But just in order to have an active post.
In order for it to be reactivated and that
Right, you have
agency
to
has,
go
okay,
through
no, I
a
understand.
hiring.
Yes.
Okay, just want to make sure. everybody's-
And I'm not sure Hamilton County is wanting to do that at the end of 6 months. That was my understanding, Lieutenant, that y'all have no plans to reinstate him to a law.
That's correct, sir.
so Commissioner Beverly, the majority of those steps would have to occur regardless. So would you be open to the 6 month term?
Yes.
All right, I'll amend the motion to reflect a 6 month suspension.
With the normal
With the
suspension.
normal procedures, yes.
And would you guys want him to sign an agreed order stating that information and have him reappear next month if it's not signed?
Yes.
Commissioner Wilbur, I'll second that.
Okay, we have a motion and a second. All in favor?
Aye.
Any opposed? Motion carries.
Okay, okay.
Sorry. Take over. Sorry, everybody just talked about it. You know, it's 6 months essentially.
Okay, the next item that we have is going to be Memphis Police Department and Podrick O'Feely. Is there someone from Memphis Police Department? Please step to the lectern, identify yourself.
Jimmy Thomas, Senior Legal Advisor, Memphis Police Department, along with.
Kathleen there until Claire's command, excuse me, lose my voice.
Good afternoon. Mr. O'Feely was resigned from the Memphis Police Department several days before he was scheduled to go before a disciplinary hearing based on an indictment that he had at Southern County, Mississippi, for child neglect. It's my understanding that those charges have now been dismissed down in Mississippi. It's my position that we should just submit the petition to the commission. Make a decision based on those facts. Doesn't change the fact that he did resign as part of his basis for decertification. He resigned a lot of other things.
Commission, have any questions?
Commissioner Jefferson, so Mr. O'Feely wound up. So before all this got cleared up, he wound up resigning from his job before all this got cleared up in court.
He did resign before it got cleared up.
I have a question for Mr. O'Feely. Mr. Peely, what was the reasoning for you resigning prior to getting this worked out in court? I mean, was there reasoning behind that or circumstances, or what do we have going on?
There was a reason, the reason why I resigned was the union advised me that that was the best course of action. And any knowledge that this would have taken place, they advised me to resign, so there would be a disciplinary record, on my status.
Commissioner Beverly, were your charges were outright dismissed or, I'm sorry, Mr. O'Feely, your criminal charges were outright dismissed?
They were remanded, they were dismissed from the higher courts, but sent back to the lower courts. It's law in Mississippi, but yes, they were ultimately dismissed.
Are you still out on bond, or is it the process still going on? And forgive my
I'm not
ignorance.
out on bond. I mean, as long as I maintain a good I guess record, or as long as I stay out of trouble, nothing will happen.
How long is that term?
Has he heard on that?
Yes, sir.
This is Steve Leffler of the Memphis Bar. I submitted for the commission's consideration a number of documents, and part of them were some of the documents from the case in Mississippi. There's an agreed order. What happened in this case was, and I was going to have Mr. O'Feely just explain to you what happened that day, but when he said that you wouldn't be taking it, that may be too much like testimony. So I'll do whatever the commission wants me to do. But as a result of an incident that happened at a public park in North Mississippi on September 11th of 24, Mr. O'Feely was out there with his wife. And she had two children, not by Mr. O'Feely. One was a 2-year-old, one was a 5-year-old. 5-year-old was on the autism spectrum. And they were about to go home. 5-year-old sees a group of older children playing, wants to go over there. They say, no, those children are too old for you. The 5-year-old starts having a tantrum, and mother's trying to handle it. Mother had recently had shoulder surgery, so Mr. O'Feely thought, well, I'll help her. He was trying to get the boy under control. The boy broke away. The wife actually pushed him away, and he backed off. Finally, they got the child into the car. And that was on Thursday. The wife did not say anything about it. She left both children with Mr. O'Feely over the weekend. The next week, the child goes to school, says something about it. The school calls DCS, and DCS files these charges against him. During the course of that, the wife also made prejudicial remarks about Mr. O'Feely. We found out that later on in the materials that you have, there's one document is very instructive in what actually happened. And it's entitled "The Motion to Remand Case." And remand is kind of like a diversion. In the wording of this is kind of strange. It says the defendant was indicted by the December 2024 DeSoto County grand jury for the crime of felony child abuse in violation of the Mississippi Code. The basis of the allegation is the defendant choked the victim listed in the indictment. The evidence that constituted the basis of the indictment was the statement given by the child in the course of a forensic interview, and the statement of Ms. O'Feely, that was Mrs. O'Feely, the child's mother and his wife. There was no supporting medical testimony. April 15th, Ms. O'Feely came to the district attorney's office. When asked, she specifically denied viewing the incident that was the basis of the indictment. This is inconsistent with the previous statement. Ms. Ophelia signed a refusal to prosecute on that date, and that refusal to prosecute is part of your materials that have been provided. The state, with the agreement of the defendant through his attorney, entered into an agreed order modifying conditions of bail with certain conditions attached. Those conditions had to do with getting some counseling and things of that nature. He did everything he was supposed to do in that regard. There was your materials have two documents from Bobby Scott, an associate's professional counseling. Part of the counseling was for anger management. The other part of the counseling was for family counseling for his relationship with his wife. In the anger management counseling report, the counselor, Mr. Piercy, said he learned how to tolerate, manage, self-regulate, and effectively express strong and challenging emotions, especially regarding frustration and anger. And more importantly, for law enforcement purposes, he learned how to minimize and restrain these strong emotions in a healthy and productive way, and should certainly be considered safe and dependable to resume any professional roles or responsibilities deemed necessary. Once those counseling sessions were completed, it's stated in the motion to remand the cause that they had been completed. And then the motion concludes based upon the totality of circumstances, most importantly, a key witness changing her statement, as well as the lack of physical injury to the child. The state cannot go further with prosecution of this case. Therefore, the state moves the matter to be remanded. And then on the order of remanding cause, it has some interesting language that I can't really interpret, but it does say that in the court having been advised, it does find that said motion is well taken, it should be sustained. The state requesting a dismissal, it says a dismissed, I think it would say a dismissal for the reasons listed in the motion. So it's hard to tell exactly what that was. I did talk to the defense attorney for Mr. Ophelia, and I didn't ask him about that. I tried calling him on the way here, and he didn't get back to me. But there is a specific provision under Mississippi statutory law that allows for that in the way that we look at as diversion.
Counsel, that was just my question. He is eligible for expungement, or
he would be eligible for expungement in that situation.
when? I'm sorry.
Well, that's the thing. Usually it would say just like in a diversion in Tennessee, he's going to be on diversion until such and such a date. All this says is to remand the file, and remand the file, quote, remand the file, close quote, is what it specifically says in the Mississippi statute. So I can't answer that question. And I'm not sure my Mississippi counsel could answer it either, but that's and your material also has some things in there just about Mr. Ophelia. He was in the Tennessee National Guard. He trained soldiers in Ukraine back in 2018 so Ukraine could join NATO. He got commendations for that, and he has a whole host of awards and commendations and materials that you have. And we would urge, well, are there any other questions?
Commissioner Goldberg, I just have a quick question. There's a letter from a professional counselor dated August 6th, where it says that Mr. Ophelia has recently gotten into a somewhat heated argument with somebody's grandmother and recommends further anger management counseling. Is Mr. Ophelia going to continue with anger management classes, or?
The anger management he was supposed to do finished when the counselor said he concluded it. However, what you do need to know in that regard is that there is a divorce pending, and I think it's pending fairly soon. Also, the two children are not related to Mr. Ophelia, so there will be once the divorce is final, there will be no reason for him to be around any of Mrs. O'Keefe's family or his own.
Okay, so the answer is he's not going to continue with anger management.
He doesn't feel anger management is necessary for him, but if that's the answer to the question.
Yes. I guess, Mr. Ophelia, that this would be a direct question. If you fail to accomplish any of the court's orders, do they have any recourse on this? Can they bring you back up on charges? What, we're trying to determine, are you still under the authority of any court?
If I'm understanding the question correctly, is if I failed any of the courses or if I haven't met them?
Failed to complete any of the
So I have not
conditions.
failed to complete any of the courses ordered by the court. I met all the court requirements as instructed. As stated, I am gonna pursue a divorce. That's what this whole time was for, to see if we can work it out, work out our relationship, and it's just not a safe relationship. I'm married the wrong person.
I guess what we don't want to make a decision today and then something happened and these charges are brought back up again.
Then, sir, I don't talk to her. I delete her number from my phone. I don't have any contact with kids. The only time I will see her is when we finalize divorce. And that would be under a professional
If I can answer your question, in the motion to remand the cause, the court, well, actually, the DA, the state, with the agreement of the defendant through his attorney, entered into an agreement to modify conditions of bail. That's where the counseling was recommended. And it says, counsel of the defendant has provided district attorney's office with proof of those conditions being complete. So he's completed all the counseling.
So he's out of the authority.
Yeah, the only way that he would run into a problem at this point is if there's a new crime committed.
That's the answer I believe we're looking for. That's kind of where I'm at as well. It's been dismissed. It can't be used.
That's this, Mr. Green, and this is more for discussion than anything else, and only because we went through this before. The whole commission went through a thing where licensed professional counselors were not eligible to do fitness for duty. And we're seeing more of these counseling forms and letters coming back saying they are able to return to law enforcement duties. That's a question that we should be cautious of. We see these counseling forms coming back, which may or may not apply in this case, but I keep seeing these things keep coming up. And based on our requirements of having a psychologist sign out fitness for duty, they really can't verify that they are or aren't. So that just something to throw on the record.
Commissioner Jeffers, I'll make a motion for no action to be taken.
Commissioner Beverly, second.
We have a motion and a second. No action, all in favor?
Aye.
Any opposed? Motion carries. Okay, the next item we have is going to be Charissa Perez, Metro Nashville Police Department. Is there someone from Metro Nashville that can please step to the lectern? We have the documents, so yeah.
Kevin Creed, Post Investigator. I did reach out to Commander Starling with the Metro National Police Department. I did get a written receipt that he received money notification to be here for this meeting.
Okay.
Investigator Creed, has this case been on the docket before, or would everybody get their one still,
This is a first setting.
just for the commission's forward?
Please step to the lectern and identify yourself.
I'm Sonny Koshi, I'm counsel through FMP for Marissa Perez here. We were fully prepared to go forward today. I contacted Agent Creed, and he said, obviously, we know who the witness was when they showed up today. We spent quite a bit of time preparing for this hearing. I think we have a strong defense to this case. It is still pending in criminal court. We received some discovery, but waiting for more. Since I'm here, I'd just like to put some comments in the record and let the obviously commission does whatever it's going to do. But basically, she's been charged with claiming overtime. The report by the investigator, it's printed out very small, so I'm gonna have to squint to read this to you. But basically it says the total time that they claim is $1,222 and some cents. And then the reason that they say that this is theft is that she was outside Davidson County for some or all of that time. And just to put you all on notice, the federal law, including 29 CFR 785.11, says if she worked, or they can't prove that she didn't work, it doesn't matter if she was at an authorized place of duty or not. As a sergeant, she was supervising like extra jobs. She was supervising other officers. So her duties were basically to be available, respond, those kind of things. There is nothing that requires her to be in county. Even if there was, she could have been charged perhaps for failure to be at a place of duty, not devoting entire time, but the allegation that she had to be in county, even though her text messages showed she was communicating. I've excerpted some of them in preparation for the hearing. What they're saying is they don't have to comply with federal law, and they charge her with felony theft and issued a press release about that. We plan to contest these charges vigorously and fully, and we think that she will be not fully exculpated, but likely there may be other action pending. I wanted to give that in case we have to come back before the commission. We look forward to a chance to address these allegations here and in front of the trial court.
Ashley Ball with legal. Is your client currently working in law enforcement?
She is not. She resigned some time ago. I didn't represent her in the.
Sure. I was going to ask, one of the options that we have when someone has a criminal case pending, just because the testimony that they give here could impact the criminal case, there's an option for an agreed order of suspension pending the resolution of the criminal matter. And so I wanted to present that option to you all, where it would be suspended, like her license would be suspended until the criminal matter was resolved, and then you come back here and proceed with the informal hearing process.
I understood that to be an option, as well as an option just to notify posts that there's litigation pending and just continue this thing. The problem really is that a suspension is an adverse action. We don't want to agree to an adverse action because that could come back to harm her. She's applying for other non-law enforcement jobs, and something like that, entering into an agreed order to that effect, when there's no proof at all before the commission, it's one thing if they would show up, I could examine whatever procedures you want to use, and then the commission makes a decision. But they have failed to respond. We are here ready and willing to contest the allegations. We don't think, quite frankly, that we should enter into anything that causes her harm when the department that has the burden of proof has introduced no proof, not just failed to meet the 100 standard.
Commissioner Wilbur, this is informal.
I know.
There's no burdens. I understand. You're a lawyer, we speak in lawyer, but she is indicted, yes?
Yes.
So we do not do anything while they are in, being accused of a crime. So I guess I'm just gonna speak to my commissioners. Do we wanna continue down or go formal? Formal?
I don't feel comfortable kicking or moving forward. We have, I take it you're in discovery, so we're past, she's been indicted by the grand jury.
Yes, she's been indicted by the grand jury. I would point out that the provisions for suspension talk about convicted, pleaded guilty, or entered a plea of nullity to any felony charge. It does not include simply being indicted. That is an improper reason for action.
Did you resign, or did she resign under investigation? Because that is in the provision.
Yes,
Okay.
I'm just trying to make the record.
I understand. I, just with an indictment pending, I don't think this is one, normally we get those an agreed order, and that's what we'd like to see, and it comes back on your own.
I believe somebody mentioned that normally the practice here is if it's the first setting to give a continuance. I'd ask for that instead. Let them come in, put on whatever they have. Let us address that as appropriate at this preliminary and formal hearing. And then the commission can vote on whether to send it to a formal.
We typically will give each side one continuance, so we could infer that Nashville would ask for one based off of their failure to hear it back in December, but that's up to the
Can I go over there and get my calendar real quick?
Investigator, did you have something you wanted to add? Sorry.
Kevin Creek, Post Investigator. The only thing I was gonna add is our next meeting is in Gallenberg next month, and same thing, the staff attorney just said. The next one in Nashville would be December 11th at 9:30 a.m. For a formal, and that would give plenty of time for Metro to get their information and hopefully you'll be able to get its full discovery by then, see where we stand.
Make a motion to table or continue this until December.
December 11th.
We believe that's the December the 11th or?
Yes, I believe that's the day. What?
Yes, table that, yeah.
9:30.
Commissioner Wilbur, I'll second.
We have a motion and a second. All in favor?
Aye.
Any opposed? Motion carries.
Thank you for your time.
Okay, the next item we have is going to be Tennessee Department of Safety and Homeland Security, Darby Drinkard. Is there somebody here from the Department of Safety? Please speak, step to the lectern and identify yourself.
Good afternoon. Erin Begley with the Tennessee Department of Safety and Homeland Security. Members of the board, I am asking today to withdraw the request to be certified on Ms. Drinkard. On September 16th, 2025, the parties reached an agreement resolving Ms. Drinkard's step 3 appeal. The parties entered into this agreed settlement to conserve time, legal resources, and Tennessee state resources. This agreement includes the department rescinding its request for decertification. Concerning the findings, the department did not cite giglio language in the termination letter. So we would ask to rescind this request pursuant to the agreement.
Commissioner Beverly, motion to take no action.
Commissioner Wilbur, Commissioner Beverly, you weren't here last time, but we had an issue, the department withdrawing, and we had documentation that something bad happened, and then there was an agreement. I guess my question is, if the commission goes forward, does this blow up your agreement?
So the agreement the agreement reached by the parties was that the department would move to rescind its request. Should the commission have questions, we do have someone available to answer the commission's questions.
Thank you.
I'll go withdraw my motion. That way you can have discussion.
Drinker here.
It is Mr. Hydrant here. Please step to the left, identify yourself.
Daniel Newburn, I'm an attorney for Ms. Drinker. Really, I guess at this point in time, I would just ask you any questions about it and we'll go from there.
We'll stay there. I'll go ahead and start with Ms. Mann. You were dismissed from the Tennessee Highway Patrol.
Yes, sir.
You want to tell me why?
I was off duty. I was contacted in the middle of the night. Well, it was probably 9:30-ish. I was at a gas station. I was contacted by my supervisor. I was given a direct order. I followed that direct order. When I realized things were not necessarily as it appeared, I removed myself from the situation.
Forgive us, it's a lot of documentation. So you're saying you just followed orders?
Yes, ma'am.
And what were those orders?
To call a record for my lieutenant.
That doesn't sound like there's anything wrong there. Do you have anything further to say about why you were fired?
If I could actually answer that for her. So, it came down that she interjected herself into what later became known as a crash from the lieutenant. The lieutenant, when he called her, said that his son was involved. She got to the scene and realized it looked like it was the case. She removed herself from it. The reason why she agreed to not continue with the appeal just doesn't want to work with the PHP. So there's really not a reason to keep appealing to get a job you no longer want. And when we made the agreement that Department of Safety and Security would rescind their request for decertification, it's really all she wants.
Commissioner Wilbur, does she want to continue working in law enforcement?
Potentially, yes.
Commissioner Green again. So the summary is your lieutenant was involved in a wreck. He called you to come and assist him with the wreck, saying it involved another family member. It turns out it was a lieutenant who may have had issues and you failed to report those. Is that a pretty basic summary of what happened?
You just summarized it pretty well.
Thank you. The document's pretty.
It's lengthy, so I was just gonna let y'all just ask questions about this.
So is there anybody from the department, safety that might like to go over just the facts of this, generally outlining what happened?
Sergeant Justin Lowell on the Tennessee Highway Patrol. I believe there's going to be another case that's coming up to the board here that we're going to address that. And there's going to be a lot of testimony there with that case that will probably kind of overlap with some of the involvement with her, if that's okay.
Commissioner Wilbur, I'll make a motion if we can to move this one to the bottom of the docket today. So we can hear the testimony or what the statements in the next one.
Commissioner Jeffers, second.
Can we have a motion a second to move it to the end of the docket? All in favor?
Aye.
Any opposed? Motion carries. And the next item we have is Tennessee Department of Safety and Homeland Security to be Terry Mulholland. Please step to the lectern, identify yourself.
Good afternoon, Commissioners. My name is Mariah McAllister. I'm with the Madison County Bar, and I have the benefit of representing Mr. Terry Mulholland today this morning. Thank you.
Thank you, Terry Mulholland.
Generally, council, can we have first actually hear from the state that's bringing this action, and then we'll hear from you second?
Yes.
Okay, thank you.
Thank you.
Please identify yourself.
Yes, sir.
I'm Sergeant Justin Roll. I'm with Tennessee Highway Patrol. Trooper Mulholland, he was hired in 2005. His current status has changed from termination to resignation in lieu of termination. Like they said earlier, that report is very long and very complex, but I'm going to go over some of the things that didn't happen that day. So on January 18, 2025, Terry Mulholland was dispatched to a crash on Highway 64 and did not conduct a thorough crash investigation, which involved his lieutenant leaving the scene of the crash. He told investigators that while he was en route to the crash, that he received a call from the sergeant who told him to take his time and was sorry to put him in a spot. He stated that the sergeant did not tell him what that spot was. Mulholland arrived on scene after the crash, Mulholland arrived on the scene after the driver of the crash vehicle left the scene. Mulholland admitted that he did not ask any questions regarding the crash and ignored the evidence on the scene. While Mulholland was on the scene, he removed his body-worn camera as deputies walked up toward him, which he initially stated that he removed it because it was crooked. Later changed that and admitted that he removed his body-worn camera to avoid capturing any video or capturing on video anything someone might say about what happened during the crash. Mulholland was told by law enforcement officers on scene that Potts was involved and or the driver of the vehicle. After Mulholland left the crash, he responded to the traffic stop where the driver was stopped in Savannah. Mulholland stated that after the deputy told him that the driver was Potts and stopped in Savannah, he went to the stop. Mulholland stated that he purposely failed to activate either camera issued to him by the department because he knew Lieutenant Potts was in the vehicle. Mulholland approached Lieutenant Potts and confirmed that Potts' son was driving the vehicle at the time. Although officers on scene noticed a cut on Lieutenant Potts' face and detected an odor of alcohol, Mulholland claimed that he did not see the cut or observe any indications that Lieutenant Potts had consumed alcohol. After the traffic stop, Lieutenant Potts had left. Multiple parties involved there went to Lieutenant Potts' son's house. Trooper Mulholland stated that he followed there to give him the registration back to the vehicle. While there, Mulholland recalled an argument taking place regarding the need for Lieutenant Potts to seek help with how much alcohol he was drinking and regarding medication. Additionally, Mulholland recalled Lieutenant Potts telling him that he would get help. Mulholland recalled that Sergeant telling him that Lieutenant Potts needed help, which further led him to believe that Lieutenant Potts was the driver. Also there on scene, he noticed that Lieutenant Potts had blood on his face. So that was on the 18th of January. On the 19th of January, Milholland said that he had a conversation with Drinkard. Drinkard told him that Potts was the driver in the vehicle, and additionally that she told Potts to leave the scene as the police were arriving at the crash scene. Milholland admitted to us that he was coached by Potts and Drinkard to stick to the story that Potts' son was driving the vehicle.
Mr. Jefferson, so I'm just now starting to put all this together. So all four of these are related to the same incident, correct? Three? Okay, but so I have Drinkard and is Mulholland and Potts. So Hodson's not part of this, correct?
The next one on the next one on the docket.
So,
Potts may not be present as well.
Commissioner Moore, so if I understand you correctly, Sergeant Drinkard instructed Milholland to lie? Or to tell, to say that Potts was not driving?
No, I don't think she instructed him to do that. I think Milholland told us that's what Drinkard had told him.
Say that again, sorry, I'm trying to grasp it.
Could you ask that question again, just so I'm clear?
No, I'm just trying to ask what, it sounded like at one point you said, Drinkard had instructed someone to lie. Did I just?
I don't think I.
Okay.
If I did,
I
was not right.
I completely probably misheard.
Commissioner Jefferson. I have seen Homeland Security bring people forth to this commission for less. And now, for whatever circumstances, wants to withdraw for this that has a lot of odds and ends that will take a lot to decipher through. Mr. Potts is not here, but considering the gravity of this circumstance for what we got, we have Drinkard and Milholland here. I wouldn't make much sense for them here.
Commissioner Moore, I just have one quick question. Is there an agreed order between your office and Milholland? No, okay, thank you.
Oh. Commissioner Drake, I'm sorry, let me be clear.
Erin Gagley with the Department of Safety and Homeland Security. There is an agreed, the department reached an agreement with Mr. Milholland. That agreement does not include a request to rescind the decertification.
Thank you.
My motion would be to send Mr. Drinkard and Mr. Milholland to a formal hearing.
And not Potts.
Well, Potts is not here, so he's gonna be default certification if he doesn't show up here shortly.
While we're still in discussion, Ms. Drinkard, you step back up just a second to your turn. Casey advises you not to answer this question. Did you advise the other responding officer not to say anything about Lieutenant Potts drinking?
When I called Trooper Milholland that night, I had not arrived to the scene yet. At that point, Lieutenant Potts had called me and told me that his son had been involved in a crash and to call a record. I called the Highway Patrol dispatch to make sure that they were aware a crash had taken place. They said it was a 1046, which means injuries. Once I talked to Lieutenant Potts, he told me no one was injured. His son wasn't injured. He had struck a guardrail or whatever he hit. So I called Trooper Milholland and told him that a record had been called. There were no injuries. Take your time getting there. There was no ill intentions on me saying that. That was me being his supervisor. I didn't want him to run lights and sirens to a crash and run into a ditch and injure himself trying to get to a crash scene where no one was injured.
I'm not in the commission, but I would be inclined to accept the Homeland Security's agreement.
This is more of a question for Homeland Security.
Homeland Security legal or Homeland Security?
I'm sorry, legal, I apologize. Before we dive off, because I can see where you're coming from. You mentioned there was potential issues that led to this agreement, you to make this agreement, correct?
I don't know if I used the word issues,
Okay.
but the department entered into the agreement to save, to conserve time, legal resources, and state resources.
You mentioned something about Giglio.
Yes. So there were 3 individuals involved in this particular incident. 3 different termination letters were issued. When we issue the termination letters, we always outline or itemize the policies, the law, the statutes, anything that we have found throughout the course of the investigation that we believe, based on the investigation, the employee has filed. In Mr. Milholland's termination letter and in Mr. Potts' termination letter, we cited the Giglio language. We did not cite the Giglio language in Ms. Drinkard's termination letter.
Thank you.
Commissioner Wilbur, I know we're kind of bouncing between 2 separate cases. I'm just gonna put it out there. I'm not ready to make a motion yet, but I'm leaning toward no action on.
I believe we have a motion. What is it?
You have a motion on the floor, so I mean, either.
What is your motion?
Motion to send, Ms. Drinkard and Mr. Milholland to formal hearing.
Ms. Drinkard, I guess I just have one question for you. You were saying you were told the trooper not to respond to lights and sirens because it was nothing. Why did Lieutenant Potts call you off duty?
I'm not sure. He knows that I'm from the area. The record drivers, everybody contacts me in that area. They know me personally. I don't know. He was my supervisor. Talk to your supervisor very regularly. I don't know.
Thank you.
I'd also, do you have an attorney in Holland? I would give you an opportunity to speak as well. I'd like to give you an opportunity to speak as well.
Yes, ma'am. Thank you.
Please just identify yourself.
Yes, ma'am. My name is Mariah McAllister. Again, I'm with the Madison County Bar, and this is Mr. Terry Milholland. I was a trooper myself, and on the back of the Highway Patrol Academy, it says, "A good name is obtained by many actions and lost by one." That's what it says. And that is the standard depending upon who you are of how matters are resolved when an issue like this arises. It isn't right, it isn't fair, but one of my law professors said it isn't, it's law school, it ain't fair school. And that's a truth. In this situation, as a side note, I myself worked with Mr. Milholland at the Capitol at protests. I have stood beside him in the face of great adversity. He is one of the most stand-up, honest people I would have ever wanted to be beside me. And I firmly believe that's the exact same thing if this matter goes to a formal hearing, that you will hear from other people. We also have Sheriff Andy Dixon here. If the commission is willing to hear from him at some point to attest to what he knows about Mr. Milholland and Mr. Milholland's character. That is essentially what's at question here. What we know now, based on what's happened so far, is that long before Mr. Milholland ever arrived to the scene of a crash, he received a phone call from his direct supervisor. There's no debate about who that is. That is Sergeant Drinkard. Her direct supervisor is Lieutenant Potts. Lieutenant Potts isn't here, I'm estimating, because he is facing criminal charges related to this entire thing. That's why he's not here. I anticipate if it went to a formal hearing tomorrow, he won't be there either, unless he's commanded to do so. I don't know. But I do know, as of last I heard, the criminal charges have not been resolved as to Mr. Potts. Mr. Potts was the lieutenant, a well-respected person. I think it shocked a lot of people when this whole event in its truth came to be known. The issue that I think the commission should have, and anybody in this room who's ever been a police officer yourself and has stood on a real scene in real time, making real decisions, you don't have the benefit of 2020, looking back at something that happened January 18th, 9+ months ago. You have to make a decision right now, today, right here. That's what he had to do. He had a sergeant call him and say, don't respond to this as a 1046 or a record increase. She told you that herself. Their documentation reflects that as well. And he didn't question it. That was his sergeant. He didn't have a reason to question what he was told to do. That's chain of command. We all know and understand that. He arrives to the scene. Mr. Potts is not there. He is already gone. Anybody that's ever stood on a real crash scene has seen when a trooper arrives, typically what happens, the deputies or officers will approach with documentation. They'll have the registration, insurance, the driver's license. They'll say, hey, just so you know, driver one said this. They give you just kind of a synopsis and then let you do your job. That's not what happened here. And nobody wants to talk about the conduct of every agency who was standing on that scene that night. Mr. Potts was gone long before Mr. Milholland ever arrived. A wrecker was already there when he got there. And all of those, that's not in this termination document because it doesn't favor the position, but it's a fact. And it is not fair to gauge him and his character based on this document alone. Mr. Milholland is willing and happy to answer whatever questions you have, and I am confident you will see his integrity in his words. I do think at some point they mentioned, well, he said it stunk or that the situation stunk. If your supervisor calls you, just as Ms. Rickford said that she did, and says, hey, disregard, but before she hangs up the phone says, I'm sorry to put you in this position. That sounds odd. I agree. But it's not illegal. That's not an illegal order. It's just odd. And he said the same. It's odd. He gets there. He gets out of the vehicle. Now, Lieutenant Potts, this is a small troop, small community. He knows and has seen Mr. Potts drive a vehicle like that one too. That is what he said. Not, I knew it was his. The other connection that is made is Mr. Potts' wife and 2 sons are standing on the scene as well. Now, I have requested and obtained body camera footage from the deputies who were there. And interestingly, the ones I have happened to cut off from the deputies the minute that he gets out of that car. But we're talking and condemning and damning Mr. Milholland for his camera being off. What I didn't see in the documentation either, his dash camera was active through a certain point in time while still on the original scene. Aiden Potts, who is the owner of the vehicle, the registration came back to Aiden. Aiden is Mr. Potts' son. Aiden tells a uniformed state trooper, I was drunk. He had no reason to think Aiden was lying. At some point, a deputy says, hey, the other driver that was involved in this is located at a traffic stop down the road. That was confusing. Again, Mr. Milhoff, because what do you mean, the other driver? It made it sound like anybody that's ever investigated a crash, there's either another vehicle or I'm not looking at the drive, one of the two. So Mr. Milhoff goes. He gets to the Savannah PD stop. Again, I asked for that footage because it is important what was on it. And again, the footage happens to end the moment somebody knows who's sitting in the back seat of that truck. But we're not talking about that either. We're here about Mr. Milholland in particular, and I understand that. Mr. Milholland arrives, he goes up, he opens the back door where Mr. Potts is seated. He is now in the vehicle of his daughter, is driving this vehicle. Potts is not. Mr. Milholland said, I didn't see the cut on his face at that time. He told the Office of Professional Accountability, later I did. Later, when we'll get to that, but he arrived at a different location, then he saw it. He asked Mr. Potts, Aiden said he was driving. Adam said yes, he was. And Adam himself has made it abundantly clear, Lieutenant Potts has. His people trusted him, and both did, because he was a good boss. They didn't question it. Should he have? Hindsight's 2020. Maybe at that point he didn't have confirmation. Aiden has said he was driving. It is Aiden's truck. His lieutenant is saying, nope, Aiden was driving, not me. Mr. Milholland lets them go. Because at that point, he does not have confirmation. Moments later, as anybody in this room's ever done, you might realize I accidentally forgot to give them back their registration or their license or whatever. I mean, we've all done that. So he looks up on the dash and sees the registration and he says, oh, sugar, I need to get it back to him. He sees them go. He goes with, arrives at the location of one of Mr. Potts' sons. They get there. Sergeant Drinker is there as well. And I don't know what happened. There was an argument about Mr. Potts having a drinking issue, medication issue. There's an argument going on internally between the family, and Ms. Drinker was there for that as well. Now, the question was, why did he call you? It's a good question, because it's a good question to ask. In obtaining statements, written statements from deputies who are on the scene, the allegation was that there was a sexual relationship there between the sergeant and the lieutenant. I do not know if that's true or not true. I just know that that's what I have in the statement. I don't know if that answers that question, but what I do know is that Mr. Milholland was not in on it, didn't have anything to do with it, was not a party to directing a wrecker to get there before he ever got there. He was not a party to authorizing Mr. Potts to leave the scene to start with. He was not a party to any willful or intentional conduct on his part. The department puts in the termination document that he ultimately, at some point, became aware, for sure, Mr. Potts was right. That was not the night of where the direct confirmation came, but later on, a day or two later. That came from a phone call from Ms. Drinker to Mr. Milholland. At some point, Lieutenant Potts is brought into that call by Ms. Drinker. You asked about, you said, one of y'all asked, you said that they were coached. It does say that, it's in the document. That's what they wrote, that he was coached on how to handle this if it was a question came from. I cannot fathom the feeling that Mr. Milholland would have had. He's been doing this 25 years, a long time. And being put he's not in a rock and a hard place here. He's in a hard place that nobody here would want to be in. Because now, if he reports something, he not only has to bypass his sergeant, he has to bypass his sergeant and his lieutenant and go straight to the top. And most people think would acknowledge and agree. You bypass chain of command, get ready. Get ready. You're gonna be the guy that nobody can trust, whether you're right or wrong. That is a truth. People that have worn the badge, I think, can acknowledge, even to a minimal extent, you can acknowledge it. It doesn't negate the fact he should have reported it once he knew for sure. No question about that. He should have. But in humility and understanding of being in his shoes in real time, I think it's understandable. Doesn't excuse it, but it's understandable.
Commissioner Wilbur, so talking about real time, yes, and you're talking about missing video, cutting off video.
Yes, ma'am.
You don't dispute that Trooper Milholland removed his body worn camera at 4:04 and did not put it back on until 6:01?
I don't know what the times are. He did remove it at some point. Yes, ma'am.
Thank you.
The dash camera, to my understanding, remained on through a set time. I do not know time frame at what point that was turned off. I don't know.
So basically, what we have here, I mean, however you want to proceed, we have a motion on the floor to send both to a formal hearing, or we can wind up, it can die for a lack of a second and then reevaluate from there. So, I mean, as far as the sake of that going, I'll just say is there a second, going once, going twice?
I just, the more discussion of that. I'm now leaning more toward your position just because it's more things are coming to light as more people take the microphone. And I think we're talking about people's careers, so let's put it all out there. So I'm going to second your motion to refer to a formal.
We have a motion and a second to move this to a formal hearing. All in favor?
Aye.
Any opposed? Motion carries.
Thank you.
And just for the record, that's for Drinker and Milholland, is that accurate?
Yes, ma'am.
Did just ask, did the commission want to hear from the sheriff or no?
I think we'll just leave it for a formal.
Thank you.
Okay, I believe now I'm gonna go back and read the names, that were not present, during roll call. Vincent Tyson. Deonta Garland. Yeah, okay, please, sir. This is, regarding Memphis Police Department. Is there anybody here from Memphis Police Department? Do you please step to the lectern, identify yourself.
Jimmy Thomas, Senior Legal Advisor for the Memphis Police Department.
Colonel Kathleen Lanier, Commander of the Internal Affairs Bureau.
Good afternoon. Mr. Garland resigned from the Memphis Police Department on March 14th of 2025. His resignation was done the same day he was scheduled to undergo a hearing for violation of personal conduct. He was arrested, charged with solicitation to wit statutory rape of a minor based on text messages that he sent to this minor. There was no dispute that these messages were sent. Officer Garland admitted to soliciting sex with a minor child who was in foster care when this occurred. As I said, he submitted his resignation the day of scheduled hearing. And we would ask that he be decertified.
Commissioner Wilbur, I'm sorry, I may have just not heard you. Are there criminal charges pending?
He was charged and arrested. I don't know what the status of those charges are now. The case is still pending, or whether it's pending indictment.
But you have evidence that this did actually occur.
In his statement to Internal Affairs, he admitted to sending the messages, and
We do have copies, some are,
We've
just
seen
prefer not
worse.
to read them.
We've seen worse, and if you want to, you could pass them around, but I can take your word for it.
Yes.
Please identify yourself, sir.
Deontay Garland.
Mr. Garland, is there currently a criminal case pending against you?
No, ma'am, the charges for solicitation, statutory has been dropped down to misdemeanor harassment, and I'm currently on the 1129 diversion for it. I think my 5th month of it, but my attorney is pushing to have that motion waived so I can come off the diversion because due to the litigation, per his words, he was saying that the family does not want to continue to persecute or prosecute due to the lack of knowledge of my intentions of this young lady that I was speaking with through social media.
Okay, I just want to, so when you're under criminal diversion, that your case is not closed, there's been no judgment entered. So you would still, your Fifth Amendment rights would still apply, and still have the right not to testify against yourself. If you wanted to enter into an agreed order of suspension, pending the closure of your diversion, you'd be eligible to do so, if the commission was interested. If you want to go ahead and have the commission hear your case today, you just may be in a position where you have to answer questions that could or could not affect your status if that this case were to be reopened.
Yes, I'm more than willing to tell my side of the story because per the union, I was advised by them to resign in lieu of termination because they're like Officer O'Feely said that would probably be the better option just based off of the given circumstances. Everything transpired within March of 2024 and nothing happened until December of that year. So from March until from March until December, there was no communication between me and this young lady once I realized how old she was. But due to the way that I was brought into the interrogation and the investigators that did interrogate me, I worked with them hand in hand. So I was not under the impression that anything was criminal at that point until they read me my rights. As far as the language that was involved throughout the text messages, I did admit to saying certain things, but those are up for interpretation based off of quote unquote Gen Z language and how us younger children or us young adults talk to each other. Once I found out how old that young lady was, the communication stopped from March until December. So there was no form of communication, any type of contact, phone calls, videos, Skype, or any type of physical interacting with the young lady from March from March, basically. So.
Commissioner Jeffers, with the information that's been given by the Memphis Police Department and what's been read out there, I make a motion to send the full care for decertification.
I'll second.
Was your motion for decertification or for formal? Sorry, this
Certification.
for decertification.
If I may, and so that I respect the decision for the certification, but from personal experience, I just want to add that I am a young guy. I'm a young male. I definitely I would say I made a hard decision with communicating with a young lady. But once I had the discernment and understanding of how old she was, there was no other form of communication. And since then, I've had to go through the rigorous of embarrassment of having family members look at me differently, my community, people looking at me differently, churches looking at me differently, just based off of them taking those specific charges and putting it into my character. And that's not the type of person that I am. During that time I was communicating, I had been going through some mental things. I had been going through a lot of, I guess, family traumas, death in the family and things of that nature, but that doesn't excuse my actions of continuing that communication. But once I was aware of how old that young lady was, I just ceased that communication altogether. There was no reason for me to communicate with her in any way, shape, or form after finding out how old she was.
This Commissioner Green, how old was she?
At the time that I was speaking to her, she told me that she was 17. And I later found out through IED and internal affairs that she was 16, I believe, in protective custody.
So how old were you at the time of the incident?
I was 24.
So that still doesn't.
Yeah,
I mean, that's 24, she's 17 and found out she was younger after that. I mean, that doesn't justify anything that you did.
But
You still yet.
I guess what I'm trying to get at is that through it being through social media, there is no necessarily means for me to know how old this person is. Like Instagram, for example, you can post pictures on Instagram and not have any type of caption showing how old you are. So there's basically just pictures. So based off of whether my social media is, there are a majority of older people, older women that contact me or I'm in contact with. So during the time frame of us communicating, I had no means to or thoughts to just say, hey, how old are you? Until later on down the road, once I found out. But after the conversations have been had, that's when the conversation ceases to exist. I'll be good.
My motion still stands.
Commissioner Beverly, I've got a question, I guess, for Memphis. They're legal. How did this kick off? Was it an anonymous tip, or was it a formal complaint?
If I may answer that, a relative of the juvenile reached out, who was actually a civilian employee of the Memphis Police Department, happened to see some text messages that were inappropriate in that juvenile's phone. And that's how it all came to be.
But not through an official law enforcement contact.
Well, they came to us being internal affairs, to report it, knowing that he was at the time a Memphis police officer.
And I guess not to minimize, but he did not encounter the juvenile in an official capacity and then began sending those messages, correct?
From my understanding, he was some type of counselor or something, where he had actions off duty with that juvenile, from what I understand. But that's how they officially met, in a capacity off duty or some type of function off duty. But it was brought to us.
Commissioner Wilbur, just to tack onto that, this says that the child was in foster care. Was he, you don't know if there's any, like, was he counseling to a foster care?
Not to our knowledge.
Okay.
It was a individual type situation, from what I understand, because I don't have the entire case file in front of me. But once it was made known that he was Memphis Police, then we began our investigation.
Don't remind the commission, we have a motion for decertification.
I did second, yes.
All in favor?
Aye.
Any opposed? Motion carries.
Thank you.
Yeah, I'm gonna go back and read again the names that were not present at the original roll call. We have Vincent Tyus. Brandon Hodson. And Joshua Potts. We have all of these individuals have had proper service.
Commissioner Jefferson, I'll make a motion for default decertification for those individual names.
Commissioner Beverly, second.
We have a motion and a second, all in favor?
Aye.
Motion carries. I do believe this brings us to the end of our formal hearing. We have a motion to adjourn.
Motion to adjourn.
Second. Ah. Hey.